Members of Parliament sitting on the Legal and Defence Committee jointly considering the UPDF Amendment Bill 2025 have interfaced with the bill and its stakeholders for the first time. The team from the Ministry of Defence, led by Minister Oboth Oboth in company of the Judge Advocate of the Court Martial Richard Tukachungurwa, presented the proposed bill to the committee.
We got a background to the amendment of the Uganda People's Defence Forces Act, CAP 330. This amendment was occasioned by a presidential directive.
Provide exceptional circumstances under which persons not otherwise subject to military law may be tried in the court martial.
A civilian is accused and the allegation that you have committed murder, the offences you have listed under the Act. For purpose of this trial, you are proposing he or she will be assigned a rank or considered a militant if it does not have a higher something like that. Because for you to be tried for a service offense, you must be in the service.
Legislators then tasked the Attorney General to explain how his tabled constitution amendments comply with the Supreme Court decision indicating that the law could be addressing a different judgment.
The justification further says this bill, some provisions, some sections of it are in compliance of the orders. You have also said recommendations. It has been used interchangeably, orders and recommendations.
In a presentation by the Judge Advocate, the amendment provides for individuals tried in the court martial to only appeal before the Court of Appeal. However, legislators took offense in how the court martial was being presented as court, yet it is not prescribed in 129, which institutes the judiciary.
It's not prudent that a case heard by 3 advocates is appealable to one High Court judge. Secondly, the General Court Martial will be trying offences of a capital nature like murder, aggravated robbery, where the High Court judge has original jurisdiction in those offences. So once it is an appealable case, there is no High Court judge can hear an appeal in a case of murder.
I'm not seeing these amendments speak to the fact that the civilian courts are inadequate in trying these matters, and therefore they warranty being taken to the court martial.
So we are asking you, Parliament, to grant the Court of Appeal jurisdiction over the decisions of the General Court Martial.
MPs questioned why the amendment wants to deflate the relevance of the judiciary, questioning why the government wants to take back the civilians to the court martial. It is then that the Attorney General told legislators that the Supreme Court did not prohibit the trial of civilians by the military courts.